guaya kajan guasa me la lukanda nen tere which ka juba sha je tu gotama no dia je ye bijani be kul benatam right now judges needed corner la look chatok ngai kon dial manan lero guasa me so go region bia manan tu bia janga please mishiben ka live video guasa me kam lero da mane kenya ban janga jan go shangan wala shanga jan dang roid bangwan ka pai bangwan ron kina dang roid jan dang roid diech sha lukomo sha nyoko mutwo ka ja rai wecha ka juba dio je chana raja longa tin kon lat ko rodian gwas me to go randa ro palpin ko ngai konan go te ka tung wan lat ko rodian ko bana lugme bana jogor luga meni jen dana bisos nan kulo nong mal ko mu kana shamal charge gor den no be beja mat kan judges kan berech right now liep kana ka kwa ga liba meni mashiga berech gwaza meni gor jen obana me bana jogor closely and mandana talk and on ana me jen judiciary mentere which ka juba kanetin content lat commission meni so bana te ngai kon wala sha luko mo cha nyoko mutwo ka je ne tin wandong kwichra no manan le ro so bi ngaje non tema ka jan gwasa me cha luko mo cha ja tuk so brodi palpin bo ka tin kon te lat ka rodien an go an wale a solution metedi ba la do ki ngum butwo re court kan wale bi adun deal kap tin content balat you know ko ngai kon dialan go right now re which no ka juba ngai kono no tera utiketin ateganetin konti lukerek machar nyer kereng machar gor kana no de kereng machar de kana delian ke chireng machar you know chedele la ramandanan dong gor kana de kana yen you know something like that ku kon le lano ne misha tuogan tama and she reg machar you know charge le look lung dong shor lo chimangai kono tama na me beti dial wala no ba kanong kon shere mangai kono no kuumɛ kiir mayardit ano chicken gornon wala ba lugumo ba jaladan wala ka on 29 ban ling no whether bulugbo won yam ki chi lugumo shebo won yam and then ban ngai ka janamene bukono ngajen wala ka chanya dangre dungwan chanya dangre bongan an wala changan ngwandien ano mluno chermi ala chang lokan ngwandien ka court lugodan lo ka court be konti ke ngin murunga no ngom le rode kene diala tit nen yana tin special wala chi peng mi di charode ref no dinen charode ref chi kwar ngwan chi ga brech no ne tingwan ko gorge jeno ba madan le rode ba je lingwa semeni no be kontin konen to bana ka ngaj ano ko ngune lat ka romani gan machar Canadian contin to core shede me chikon neno ni ray which ka juba so shimugui kon mongwasa mene ken tereti jian tone tigreti jian jenti jen cha ngajanu niga gwade dane cha ga yen gaja no tel gwadin mishiko oten so only tijen yen gwadan tiketen so biadil ngajenu tungwan lat ko rodian wala tidial bana ka ngajenu ngum le rode sidenen gwam re tijen tamakaten you can see them tigare tijen chemnen yana mo gwada mo ko te tungwan te borian lado wala but take a question kel mo ngod gwam de ko dan ti keje menen yen michal ke me la SSBC ko kungwagle nongan wale take mi kana gorgwad me dong me de yenen ka title mo ne me chelele for session of court proceeding for Potkang ngular kana mo Potkang right now so this should be the question then are in take je right so ngode bana mandan le ro ban jilim gwas me ko ngode won kon wonyam ali konike no bikaben adi nenen wo chicken title chicken gorno a court case chicken gor shoot Potkang ai kono no chi jan la kwero ni Dr. Machar jala kwero man Ramadan en la man la first vice president ka commander in chief ka kuumɛ spilayo but why chicken wolo gori Potkang oni no kala dana lat kan kwada mene ngoda lip kon mandana lat ken gwas me ko bantin kon la ruden bana ka ngai right now these are the native content right commandant level
control of these proceedings supported or assisted by Justice Stephen Simon as well as Justice Isaac Pur Majak, who were appointed by the country's Chief Justice to handle this case at hand. And of course, viewers, if you've just seen or you've watched at Freedom Hall, the hall today is full. People from all walks of life were allowed to be able to attend this session. We have also national and international observers who happen to turn up to be part of these court proceedings at Freedom Hall. And we also have scholars, those who are actually taking up law studies and those who are also, doing the studies to.
So, kamilin kon magwaza me Dr. Machar ke court case den wale Kennedy ala content chaka yen kel of course milin kon magwaza me kajan ler lakme. Jen and lugan wale chinetung wan chika bentin along natung one, chinetung wan chika bere. Kennedy to no te international community ticketing jerem ngai kona ka gwade dan ti kon ne cha je lugo ne china chicken be cha no no ti kan ti de berech pen kan ka manage media lokana all that but right now it look like thing chikaru and garen wale ko chala tekne to wan long ti cha ti chicken ka lat en wana mo ko bi kan mandan le rode ka jen court case me bi kan gwich no neme ejon shang an wan dien so bekor ngajenu shang me very unique day en wale ajeno baring machar baje yen ke baje lunya kan dangro today dong bikon me bana jelinga gwa ka do badanen len ngwarudin ke je ashremen challenge gwa men och ne dia chika wen money netin contin bit mandana talk scholarly everybody shaja law wale ko biken appear ka court ko biken jaje bawo kan kuumɛ South Sudan la kim yadit ba jolinga ken tega ano men balat kach wala talk wala ngum le road of course jaja ngajo already international community no manlat ke kuumɛ kiir mayardit kan te gadero ka these are the people in corner to kare shi riek machar to ngwane money kwalo nang na blame kwalo nang ka karing machar jan mandana le roda kare ler kana me milin corner me kim to kan tem ko this is a live event le roda en tamare week juba adio ja kon dial channel le bulun ka ken all these 5 days ko ne ka jan shenge dan cha look cha ja John ke ja cha ja kapchong ja chikon ngajen wo cha yot ka date 29 nyok chikon dia longan wala no dong te baj de rodian la re week juba of course chirama ngai kon tok but right now cha ne ngwan cha kan nong re which kan e to connection kon nong ba look ba jo gwi te ka chirama ngai kon wonen wo look de je look of course ba je de look ka do mi ba linga ne ideal lo ba ga de ba ka lar ka jen wala kan ne kiir mayadi de ti go de jano de ka reng ma cha de kan yena for good a chicken a dear ka te ga dana dong de te ka South Sudan is got their main idea is to put Dr. Machar behind bar so na magui kono no shediam go right but kake gwaye shedeman dana ngui keneje shit ko ngai kon ko gwaze dan me chi kori to go jala blame ke liu cha de kam reng Machar no reng Machar ja ramadan kan kon man to kan kon ngai gwaze mene kan kon mishal ke de kon surely what will happen and wale ko ngai kon no ba bi Dr. Machar la tok kana ji ko ara diala wala ba ke look mi la kai ki luk mi la tok cher ngai kon ano te tung wan long to lat ko rodian so to tone ka te bu kon ngaji right now ngoda kan netin kontin dong bukul bun gwalo kan ga ben so kwalali meke jen menen yena men tam tine ideal to gwadum right ni to content ka SSVC men mi dong she needed content ba lugmo ba je bluk chiga lunjok so ngoda kan ne benen kwar so mi kware ben le dio jaban madan le rodo ban ngaje gwa ko nono gor jenu ban rodan palpin katin content lat karodian Meradian man bana ngachi ngai kon dia len wale ka chanyan dangro wida bangwan ka pai bangoron kin dangro jan dangro wida diech re wike juba ajen changan ngwandien ka look Dr. Machar jen chang an ngwandien de kon lar no all the judges shika ben la different lawyer gare machar shika ben jinetin kontin la persecutory ka kum kirma yadid ba shika ben so ne dial katin wana mo ba mandana la solution way forward ba je gwichan wale ka jan shanga mene jan shiane no she all che tiang gwada dan tini dial tugitin che tiang a che wo pot che mangai kona mene ko reality ka tigwe ken wo ba dealing ke ba ngaja gwa win mon ke li kwa ka document ke gwe ke ka do ba dan de gwe ke ja ngai kon dial ti che tien go mu te chi ngwana chi kan wo gwa ala future of South Sudan te ka jan dola wale dol ka meni ka chanya ndang ro bang man ka jan pa bang ron kin dang yan dang ro die che me telm ro dien malat ke lo be South Sudan be je she ba gwa kana me ban wari be ka lat ka positioned ko kanete mo te ba loski ba guje no kanete talot today ko chaka humiliated nuare chaka humiliate kirma yadit ka kor gwan ber ngai kon dial kon lat karodian right so titi lat ka ko bi nuare bi ka talot ke ba ngaje no kanete talot ka ngai kon dialo to dialati lat ke kuma kirma yadit ko gore jeno ba nuare ba guje mon no quicken ngwak akodi reng machar mo gwanat of course the me chaling me change cha de nang ka kama ke ka gwalok reng machar de nang gwalok lo chiri dial chicago alo kwau nyone je ajen ta ya dane gwe ke jaga barai na che jojo gwano jaram dane cha target chen mangai kono already jerman chaling ka different law eureka gor kano ba lugo ba lugo gwa different lawyer garamachar shikana bon kin yadit ba shikana dak negati diale kon lin kon ke shika chonga bum are gwadada antigatin so beja of course beja cause mu te charge lugo ngwana me balare ki mu te cha tok charge gor balari method re wichin winami so ngode wo kon ko woniam ko ken judges ken gane benon gwada me no di en antigatin dio je meni jana nya kiir mayardit I think somebody mentioned government ane ti ka kwar din kanen so ngod tel mi chan la
that this event is live on our YouTube those who could not
okay so titi shirmiling yana bana tin ko na lat ko bana ka linkel cause the reality ni kategoro ba ngach ka tanda ndon de ka lingaja of course kan Nuer Online TV channel gore jeno ne diala kontela family telan wori gore jeno de en charuni na to gwasmo cause gore je biya ngwan biya kalin kata dana dol ke je reason dana shikon to diala kon kanon la de to ngai kon ka policy dum YouTube cha gurno ba tidial misia dun mi chiti tenen gwada mo ba non kelu jala dino dong bunaro je kano dong ba non gwatot but yo me gwada dan right tin I will make sure that be jowda be je lip kon ko bi ajeling madan le haro dong bu kon lar metot ka ta dan le ngwaru dinga je right now kan judges kan gana bendio je chi don men bakel dong den ta well dong bi ben ka jame ne chicken lar no de ka ben ka ta mi chita bangwan but right now cha ta bangwan tin if you fight you don't have 5 minutes karodian bala la ta well so na me metitin shedemela kona lareno reason and dana dongi kona men go case me de gorne ideal o future South Sudan te ka jena me malat kona mo te charge charge gur ke charge la de gwa ka do dana go jenda let ke je ya dil ngaje no ne me berek to wan be kanung re which ka South Sudan ka chi mu gwa mu chi mu gor ke no de to no ko ngai kon dialo ngo ne eneran gor jeno der te keting mu gwa shi tanat gor de te gone so na meni shed chi mi chi chong ajan mu gor jeno ba dil gor ne dial bana judges bana kalif chana men lo ka metot gwa samane okay ngode liep kane jaji second liep ko to biga bereja tama dio gaja jan china chike nyur no ke chike gwik ngai kona gwano ne dialati kane de kon la gwech keten kontin chiwa gwada dana dong ba lugume ba jo latin ko ne dial chaka law chagu jeno case mi din mogoro ba long ke ba lukke ba ngaja gwano tuogede no din nen gade kare rejemi kendial din tadanan teloy din gaja gan ma chara janine kujimi ngoda judge ni ken gana ben
Selector Isaka Phantom.
So yeah, jagur kono yer kan live video ni right now. Go she can video she can play mo shima gwa ye chong. Okay, mapa yelling interruption music and a lot kui music and music me music I play ka don't na ka live video especially right now cook on stream ka YouTube la ngwan to ngwan la ka yera so they are trying to spoil dio je later by lo je lo me don't take militen by nyok mu waja watch ko sa gwan ma to dio je tele but la take issue ndo la to me misha music cha je play yaga music you're gonna play in the middle of this so dio jen wo chi chong but it's okay for them bana gormana le rode chaga already go gor jena bantin kon le rubana ka ngaj but yo mi ci joy ben ba nong ya
Advocates Act 2013. This is what is happening in the court. Expectations are high from the audience. This is the beginning of the country's.
Jowling and Magwasme wa Nathan Conti la different lawyer, Dr. Machar wa Nate Condition license then expert, wa can shall caption chicken to participate in Waleka Jowda and Chaladakin. Adio Jeshang and Million Con and Chikon Jeremy, but more still. Wala na jen dong she can be participate kata dan lat Canadian tamake jan Guatemala. Kani she ne te la judge skill or Dr. Machar tin chalado she license and nature jack wa can she can be participate kajan court session on wale ka jawdana cha kwene kan Guatemala. You know wala kujino what will happen ke team and Dr. Machar chalado she can be participate but chaluno to chi she look charge win now.
This is all about the constitution of the country. Constitution indicates nobody is taller than it. This is all about the national constitution. Regionally, internationally, the law stands taller than anybody, whether in government or in private. This is all about it. Let me give the microphone to Leila Osman to give you more updates about this court hearing.
Thank you, Martin Joseph, my colleague Peter Mori, and Martin Kose, live reporting from at Freedom Hall here. Just a brief reminder for those who could have just joined us today during the fourth day of the court proceeding.
So latkem right now natin content gwas money sometimes in word that is stressed she can go no don't te tong ba lat kite brother lat ngai kon dia le gwa lok te malalar ke no jin bi jin la neutral mi jin kwar ke jin jash ko ba ten content la de ba ko la ngajen o ko ke chiro bu mo ke side. But right now, kata jukona linga tama la natin konti la ne Dr. Machar shaka galado kan chicken de participate coach license kian shika extra so na many ngoda bo a question kel ano ko mi to ko pujuno chine de ti chicken de participate ki chicken tin la rodian chicken de participate la to ko manan latka but not yet still ne de chalan me chang chirum kan ero kine diok so ne to kan de content chalado iba ita caption kata dan chadinga dentama but not yet still kan nya jen dio ja babling ka judges yo gwa dan an chika ben kan jaine ko jaine tam ngor kan gana ben ngot kan jor so amen mi mo chika bere yo dan ba man la tok de ba kula ngaj man bi ngai gwa se men wala chang ka endang ro bangwan ka pai bangwaron kin dang ro di jan chang an ngwande ko ba luka me no ba ja gor nyok ke case dung Dr. Machar no ke luka me dan chi tore we can answer jan dan talk ko jan dan chi talk jan chang mi kana sir gwade dane shingwana nwari shika gak tin kanetin kontin la de ni jana ki de na SPDF tin te pinke me yadi of course ngai kon dial kon lat korean no komun en ran ngaje tarka me dane e le roda take me shala ne right now don't go and wodi yana ngach no me shala ne dio je kon dial ngach ramidan la order to by the way jan wudi shala majuro la jen la order to bano nyinya ke ngwane another thing ne re kon de chicken career gwade dan chikore tokten bibi janalo inat ka tai dan chicken career kaja ko nane ne itimo nakan ngani je ga long naka first time ngoda kan ko je chal kame we yara du kan dak kon de ale kon de chicken la chana kanen before that tell me chirod na lat no ko shingwani anwari loidin che jat kate jegde kon ala da kum kem yadi so they decided no bine with mo bine dil cabinet din ti chine lut ke chine go jano ko kon ne kien no ki de kon la no NSSPDF chaga let go big and bigen ga gang la de ko big and bigen ga that was the main thing in the first place ka kum kem yadi so tell me radian mi kujemi ko mi ke ne timo lana jeno de kana de kan ka gang requente kon e chalat netin kontila ngwanen wari die je she chajeling che to gane anta mi chide wona na ko ba le yene na ba le odi du mi chalinga kir ne so kir ajen la tidiality jaram dan lo go bi mal ben jaram dan yerte dial okay so tidiality ne de ka kula go de me kan kir point ka ro kon wo character kon la de so ki da ro kon wo jen den de dial de kun la so jen me sap en cha kula krede na mini guru jati dial de ka go but the person ma logo de maldera ben ngai konen wongu kir so na me dara de kon tikan ngai katin kon lat ko de no lat ka rodi na de do ba dien mal be ben jere wich ka juba ki ka South Sudan ke liu so whatever they decide today be decision magwana jen be jen ngre wi ka South Sudan so mi chikana la da wo magwa mi dong de we wonyam lo bikana biken ka fare chicken bong chicken balat chicken lat kana mentame you know no no natin kontin chayen you know yana ka dwere chicken lat ka ngai kona ne ken yamala reminding de kora remind ka je yene yan ka ga de shala de defense team lawyer dunga machar no shiri dien riek money wa riek kuumɛ mayardit ne ten konde de ne de kana follow up kana de shal ke citizen ne de sha kam power ke sha kam long ko kana ten content dong de mal de jati wana but instead kan kana ben gor chere ngai kon dia letter mi sha gorten ka de ngade kula blame ke ngam de tech de kon je no ya she kuumɛ SPLIO kana ten konde citizen ne de sha kula kam power no gor ne mene but ko ji kana gur what do you think so de kon ngaje no beje met okay so on wale shangan ngwandien no ka lugan me mbana lingane no wale no lugo me baje dil nyorle already chetunga ta wel mete kan ngwan I don't think no lugo me bejan ko right now gwale dan ngai kon ne cheteke 30 minute karwaden wala dong beteke 30 minute already ki be 1 hour be nang but not yet we mean that waje to go ke 10 and 10:30 which mean that but okay 11 but me waje to contem but okay 10:30 so still ko ngode 10:05 right now take a minute dang di janta well korun wang and then ngode kan ne jako baje to ko de je riune ndi alchi ke chop pare jamo ne de content chingot ke judge ne ke jilo but gwate changa che kon lingano jilo ko ne kan la no e ba to ke 9 check 900 ke 930 day to ka 930 but right now chudur shele wone ka 10 mitimin take min dang die so they can really can but ngode tell me shoda na lat so can tam can follow up gwa shirme ngai kone kuumɛ SPLIO pin dakran machal nokan mal gor kan mal mala issue janane shikire che gono te mal medeben yoy kente dial yoy ken ka wi dakran machar tijen kwala kanta tama tinanu whatever 2013 e dana chichuok who will be blamed for that gwada shi ne teach of more than 400,000 people chika parish ke chika lu ka chanore chukwe 25,000 cha yeken cha gabat ngum betu kan tama ngum balat netin kontilat ke look of course ngai konen code me shwale special code chi hybrid code jena de reng macha der je look kadar kirma yadit der je look bana but kira ina ngode cha je lungo kan look wa lungi reng machar ke case dung nasser ka ken jale kone che kan ko latai kan wer kan ganna ka je civilian na mani ngode a different story ko tel mi chana la tel mi shoda na laran tam ti dial ngoda wo kana gwa but when time come ka lokten konan ba luka gwasen be adil ngajen o be situation me mlin konan wale ana bela magwa right now ngoda ngwana be ke ngwana je ke tel mi shoda lat so bu konte ngai ko luka me na togde ba magwa be jenung ke bela nong me jagba so na me gor jen ode kon diaru na real ka katin kon telat karodien ne tine kanetin kontin la prosecutory nyen kirma yadit ken tatone prosecution team ken ten nyam tone gwadamo kan netin kontin lan garama charngu kan ken nyot and wala decision ba make be South Sudan be jager jeno be South Sudan be tekamal ke jeno be tekakori so can two thing right now right corner ni ko bana tok bana jalat ano mal tetet kanga tetet ka judge ni wale ano bina we wonyam rate tini bele toka ke you know so gor jeno de kon diale de kon ke linga nono so netiti kanetin kontin nen yanka tin gorga jano dong de gan macha de jalun ke de gan macha de triti jen banti dial band ka ngajen walo ngumle rode win mon guje tin kona lat karodian okay gui kenten content to ko goro jano ba ngaje wala no dwor we je wala we gwa netin kontin la kwarngut ke jor wala dio je bala mi chek che bo won yam ba le la mi chek ko ngai ke je gwano tidia cha ga tung ga shenge dan telum de dien ma ba gor bo won yam long ke tung wan ba lat so gor e ban de linga tini long ano ngum le roda okay tidia la ti ne tung wan pal nan wo ma la be ano what do you think gwen no luga me ba won ya magwa wala ba wejek sharu gore pingwa me mi jiram dong ling tok na tung ne internas lugan wale bala look mi chek jen go bna won yam ki china ba won yam man biya ngaj are loka me biya ngaj no shane tin kontin la different lawyer daktem machar chara do ken chaka kap chong ne te konde chala do shilai sen kin chika expired ka do bran ku ka expire ke je kalai san to tony wa lat ka ketet kuumɛ kiir mayardit ko Canadian content ka power ka Canadian content logo no binede ti bi kalai sen kin bi ken ka jek before kan lukana to ko ne ka chanya dangro yidiro no chika wa but chaka pin o de kan license kin de kan ka renew yan tai dan kan lat ka ja bona me chi jalla big deal on big deal o ten konde lat ke jojken ko renewing license chi me de jan awone amala to ko telerek but gwada me ngai ke ten konan to lien ke ten konde lat korodian men mi changa jeno wongwana wo kenede yes talk chiloina test and wale of course gwe jen won wala dong de da jan changa jok nating one this is what people are expecting, that today should be the last day of Dr. Machar in court. So people are expecting good news today instead of bad news, because the releasing of Dr. Machar, many people thought that should be the only way forward for South Sudan to find a lasting peace. So, Jendan and Kuni Dial can expect in a minute. And about deciding judges based on Manchikana Okwen Ray all the documentation submitted ko ne take document cha submit ngai kon dia le document re te cha submit lo baken ko gwich no take te cha la da lung an gwadi dani kwa wargana kwa kala re keje shinaro che ko ne tinaro ajenu city sam ka de kono de peace de kan monitor chinanyo ro ajenu jukuma sfelayo kani nana ki depend lo yare sfelayo tin content kwa gan machar kwa defend chikala nu ring machar tele miche yar la medane cha jekan wo chijia dara last ceasefire violation ka jowda nen chala de ken sinanyo rajeno ne ba ka constitution cha lat dung South Sudan can reply peace agreement cha garpin warek ma cha de suspend ka by president unless she peace agreement che tool ke cha collapse so ka tem nen kona hukum kir mayardit kan peace agreement kana konjek peace agreement jaten so ko kuje makolar kan peace agreement jaten nyu jen go telemi cha yar Dr. Machar na duno mutual cease fire violation me de lat ke de nyot netin kon tela side sam kan de jeno ke cease fire monitoring de kan wo gwal dan ke tokten de kan na uti jeno ngum choda la de ngum choda nyot cher ngai kon de no netin kon tin lat karik shikanetin kon tela ngenen wari of course ngai kon netin kon tin lakati kanetin kon tin lane kir mayardit chede mendana ngai kone tele rami mo michire chelat gernetin kon tin la de ne SSPD ko kane rekonde sha in structure cha jugo no yen we are gore goten kontum nganatin we are gore jen wo bian wer be ko disarm kede diala to dio je konti ngai tin no of course karik lip kone court case ko right now lip kone judges chemen pai kon la tema ano judge ne bigaben gwade dan me kore tokten dio jerunen to wantama roine na ke kwi majuro no majur janam dan sha yir shabat ke liu gwade dan bat chinere wan chikeliu before that kan ye majur kan jen kan kor kan network me kore to no chana jugo no yen woje kan de nitine in state me cha na respond cha chol kwang chorale cha kwanya la governor before kan kwanya la governor jen kan Johnson lun cha jugo no we are kanasr you know na ngede ne kan wena mo chana ngaje no en wuri chal kame Michelle Kame Johnson lun jen chaja kwanya la Ramadan could disarmament kuje carried out kiramdan be mej buko kep and over dana dong de ja law go je ko de na no they can have been lot and go ite ke kuumɛ me de beger gegen jen wo can hali can kabenak ki can disarmament can carried out kan to shi na shi hali kan tenyu won Kenya mano yana woje de ni gwad mnonga ni national force national army but you can look kan tele Michelle ke unified force mananga dorun you know Shikir bon she lok bonora karing machar she organ one check gor to gore kir mi yadi dio je kondial we did follow up the case right so she kana look mi do ko larno she Dr. Machar te kerego a point en kir mi yadi but ko ngai konta dan en tungot kir mi yadi keje a lot dial anything mi jeng mi chalat ba je ladwi Dr. Machar you know ene duar mi chi jak ba ladwi Dr. Machar so de ngande ko go de mi la dunu mi je la ja le bi la wi ramanda na ko la your opposition katel mi kana la tera mi ma chila wo gwa dan tiketin you know but la wana kana no reken jan kwa la no ne kon kwa target kan were so mission mo bana all the decision in ba me gwa da me bana ka dealing gwa you know ka kuumɛ kir mayardit no kene kuumɛ Dr. Machar to diality no telemi chana luitin but men bana ngaiten chala da tema ka ngoda kan kono nyam ne kon right gwa da mene tin right ka SSBC lat ken no ne cha Dr. Machar cha defend lawyer ke ne dangro cha ka kapjong ko chi license ken sika expire ke sika je ka jan do bana lat ken je temri lat ken no konchi poro jenon wala jan shangan ngwandien ka court session dung tak Dr. Machar gwal me tim cha gor ka jan na mene denem gwas mene me cha gor ka jan me tuogane so ude me chikan wa gana gor no podkang kana netin kokien bugo woka court session and wale ala men non kon gwada mani o bane ngaje no la they are trying ko they can podcast they can la wide lo system ti way mo kwa targani netin kontin tere we can asir ka taye dane ci do ci toje dio if you guys can remember me dan chan wara shaka daga ne te ka style counties e ka friendly counties dio je me len kon ke me ngai kon me dan ci oda lat taye dane chana cha categorize ke je new the gen wo chan wara bo cha gu je no ba ka da ke that way until la ran la jang la ja ngak ka gogdu ba ju do ni jin karwa do bunware ko ken bi ga be de she ka ne to go you know by your pelon gwad mo go yen but when your time come ba ji lo nyoka menanga je ka gwa chulchul ci kana gwi janu no ba ji ngak tin Mugoro, memet kon wari at kon kel. All these things ten content mess all the mess up ten kwaralat ke queen and kon lan wari. Dia ja de ke chong. You know, de kan chong. So tem chiti je chicken dia talk ban wer ba la de je and then after that ba belen wari. Especially ko la kwan wari. No ko cha joja go antemen go Ramadan bel ke lung riek machar en ideal. Netin kontila ne kiir mayardit. These are the people that are looking for position. Rei kumeka. Ashima netin kona dong ordinary people. Komijini guji ordinary people they don't complain. You know, lat kene jeno mala be. But ne kon take a position again the content kwa na kwala nek whoever mi mo met ke dakame char ki la ro yung macha tele le dur ba guji no jini jira ma ji ki ba ji target ken. So guji kona ne madara mo go no. Titi kati charen lot. Ngode leave koni judge jingwoni na ngoda kan ben michi jingwoni shik ben le dio ja bana ti dial bana kalingen full tin kon lat karodian vale not forget and wale bala kel nyudo dong de maldere ben ke de wona korde go wonyam so let not forget that alamichene men wale ba mal bejenong ke ba kor bejenong. These are the two things tin kon ban expect and wale kone ideal gorge jeno mal derben de South Sudan der te kamal but mo can charge gore na tin content quality view come ne the content ka tin te ka position dit no and wo be mal be bere wi ka South Sudan be mal be ko ni amde ka jeno ne ideal agenda na ko expect no mal abi re wi ka South Sudan we ja te kamal. You know, these are the things that people are expecting. But need content reja more kene to kon dong de la no boom weekend chicken go no te mal me deben tene relate ka mal ma gorgan jono de kan civilian de kan display sire me kan lat ka panal chalat ki equatoria ne ko no kwa target. These are the people in kon shun kel kereng machar which is very wrong which me gorga jono ba woni am la ne dia kan let kel chagu gin one side no gente gare ko ne mando den mala gor ke long ala ne tin kontin lat ke je la their side la ja lenka baling no ken ngum gor ken ki ngum lat ken yo biya kula no ne ti lo ken ne mene you know anyok mi ta jogo no gare ne chine ye gor you know what rodun they should have listened kono mo agwan mutu civilians and teleke de interten teleke kuumɛ da dien bone me ku kan yore jega je reso ne ken jen por kan ken odong bu gor kare that is it term da dien metwok bana me charge gore wa ye kap ka bom chwa de tugdun chwa je lep you know no mo der kulo gwade ne me che chwong so mo gor kuumɛ mo gor jeno biti dial bika go gor kano bi ken noer bi ken ko moy ke freedom of expressing themselves ko dong bi ken gor jeno buga na bi ken ka silent charge gor no take me de talk. So all this thing bokulo gwade one side mo ko target kwa ne ko ken kwa ka le de ka jete right now noer ken kwa target call their territory tel gwade dien adorian chade ko ka dor jan tin kon talk tin Canadian content tin nyin korodian la jang kan nyin korodian but gwa men were kan kula nyin to ne kan de ko la de ni kem ya di tin chajiden mat kan were kan jang no kan do ko ken especially ted kisholo number gwa na mashabet chat mut. So this thing go region de content kan lian ngai ne jen go la systematic way ko na target ke jama we can were no ka trade we ka South Sudan ne men shi ma gwa chi chong so ti dial la gorno bana kongwich la ne ti la ko na ti ken ngum gorian special me jin good leader bu jogo no ngum la riek you know mi kani jogo go ne bne chon ka you should allow them chi o de go je no bika George e ko chi ka rach na ma cha me jeg de so chi go no te ram do dien me dong de de mo gwa de jogor so jine je kwa dominata cheng ni la rami mo mer la randa wuja chu je gwe no te mi jeng la da na ma jaten na ma che de ten ha wi mon ke lu la gor ne di al ba ga par sometime don di gu jo nga ga chenien you don't know no ram bo dong len ji ka pel so chiran che de kap ka bom so na me ajan la rodan wala re wicha ka South Sudan che me len kono me no nwari wa chwara rach nwari biede chwa ye chwa ten ko ken chwa ga join ka of course me kon gi kon la tok ka kon e ten jok te don kan kari na ngaje no ka ngane ko jina la ro ngaje jin nga chi ngaje no ngum le rode you know but when bina telemulat ke you know all those things de ko kulo god ka jin gwa bimandan de un yam ga jabi ngat and de un yam di you know ka de ne ga de ga lo ga di mi shi ngayon then tali problem so ti di al bi go but not when then gujin janu rada di na jan bulat bi la do kujiro no ram ko ji marginalize ko la de jek so na me che chong so mi jan do dan de ko nyam je this is wrong and now de ko dan yek wake up so chere me gui kono monen tama cha kon yek yim le already but chen yon je no kon bana chong lora bang gor je no bana wo nyam ken liep kan ni right now liep kan ni judge ke je lo kwaran dir kan liep ko mone kan kwala leba so dio je le mo ka ben ya dio je choro da bai so ne titi ngot ka jor kwalim ne ke yo mi ka bereji yo then ba luk ba je kula tok shedamen ti kon ling na mandan la jilok bendien dio je te ga ngot gem jogomi ko tam ti ne dial chi ka tiang you know china tiang re jamo ne dia jenen yana bon national security jelga kam na dan gwanamo jemenen yana mo ko zen gwada mone atine tu wan tegitin tilla scholarly tegitin ne dia to be win to goal ko wala chana chaka lawno buko lienga mana le rode to me chere me again the chere ga final court session changna mo kwikon kujadana bo lentno ko kwikon la gwantar mlugaji ja go ni chang no dara ji kam chon la go no be jidil mi long so dio je la ban mandan le rodo ban jenga so liep kene kwar be kan decision en be kan ben nyoko malat kene no ngumi ji kan ojek ka document e ko ne cha submit teken ka chong wala tele ka chong ka me chala no special court te ka wa e kuumɛ ye be pinyo ka kuumɛ cha te ka chong michal ka hybrid court and hybrid court amone kare kon te chon ko de ka dar ma cha de kan lu ka chi kan de lu ni rek ma char ba ko rade de kan lu bo me ne kir ka de root cause e da ne chi to ke 2013 de nyok ba ka mi gor ga jeno ba tar ba janga ko ngai kon no ne dia le tel mi cha na gor ne me da ne kwa mal yal kwa galat ai de to man peace initiative ki na male kwa tan bo ga 2018 peace agreement ne tan ga Khartoum no tel mi cha man address even 2015 me ko ko to ke 2016 tel mi cha lat no de lar no charut ko cha je gno ngo en me nyi na ka je yengo no tel mi cha lat ko te ban ngai kon diale eno kore dane to ke 2013 lokin me yadit ko by election ba jelat ko ramadan la opposition keje Dr. machar ko reng machar je bro de chung kire no so ngai ka tar ba cha ja address angu mulokire jamo en go ba queen kware ba jala ki bireng machar barode chunga la kwar so ngai kon diale ngai ko reason amo o point kir me yadit che gor no be power be jelus that's it agenda at work so jenta dan len ngaro din keja all this thing blaming reng machar jen lar ke no chi chuong ngai karam dan lede even international community ngai karam dan te kedwer but right now bina ko dio je dwala na ke kir you know dwala na ke kir do dan dwala na ke kir ala kir you know tele mi chanen mo gwam te ke right now right corner so jaka ne tungwan ko bika dwal ba ke kir no let kir do what he likes international community dio je if you guys can remember would shall kame Omar Bashir ki kwer dung Sudan ngayen me jege dana chelet ka Darfur che ji Darfur che ga negene che jen sa che lad fai by the way and kwer Sudan Omer Bashir but chago ne wa de je yen me cha je pel ko jen te kwer ka mene ma chago no dong de je jing mi che kwer kulte che kulatok but right now ngai kono no mo kana na tok right now yare ti jen gwadra antetin ko cha yen ne ken kataya dane che jen sai che je kedar ke but cha yen je ne ken me chi par ne ken yurin badak ngoda men tem gor ga jen wo jen de je di look international community ko ngai kon dialon to dial tene ka tilat ke ne to ko tet me kir bono mi guyen tem cha je ti teram joge de awojen liep ke je amen mi chi power che took then after that chi power che took and then ba je ti kata dan che na che ne ga je je shanen bono wal ne ga gwaze ne ben museben me menen yena men tama wote kuer ga te de je long te nyot rai wich ka Uganda kai janane bani nyok nyode wich dung South Sudan ram joge di even international community ngai kan no kir kan musebeni they are committing a crime wonten right now an army embargo chalat alme chalat wo cha me cha ka bi kok kuumɛ South Sudan angum selel yani helicopter cha ga cha gan chimni chi kan ga jak re wich ka South Sudan chi kan ga jak bo amene tang ne meti didial and meje nako kon tem kon wala yene be ka Uganda you know so an army embargo lat ka gwadme is a joke tell me cha implement ga kwide there's nothing done about it you know again mukul nen tem ngode shulken wuken ji yuan jogo no army embargo akwa lift ko bine ko while they are doing it kepin ya tine no mo they are doing this thing secretly. So ne di shiro ma dio je shaka de trust ko kane te lat keturian lot chikan gore no te ga South Sudan mi bo go reng machar je la tike dia no man je kan kwen ga kwide ke je kan te dial ga kwide so we da reng machar bane ngaje go ano telem bro lut dia nen gwasa me ka jen chamber me ne te ngwan shiga shop gwa da na wa lugwa je lukten coordinating link Gorkano they want to be on the right side of this story Tadian ngai kone ngai ken no riang machar yene cha yene unlawful and unconstitutional ko blame ke liu te ka kiir mayardit so mission mo ngai ka jene ideal right now chi do men dangro ba woka 10:30 mi je chup ka 10:30 oje biner ko la judges bika ben ko bi chup chicken tai dan chicken lat ke chicken bel chikarulu mo chicken by late bani cause me chala ne lar gen wo de ya antem chicken chup already you know bana man to go bana ngach okay yeah chicken chup bana man to kan ton be region right now chicken chup rejo ne de ti woken kamangar Kennedy so chang madan lat ka shaja de link so telengu we will see manan to bana jordian ban jokule lem no wala yo mu kan jowo go kan leb bu kon link ta okay na antema shika ku shobrech shika bereja tama kan kwarshe malat kono won ke 10:30 shinetin konti la kwarshe ke shobrech so bana ku gwini mandana le rode entama no ngum bro laden walle no bro shu much ke pen mude do gor ke jama donga jiram modeten kono to de ka gor ko gor jeno bi tin kon to bi ka ngaje no ka nguni to kon let wait judges ni kan ete ti shika berech already bana dio je court baje tuko tema no okay tuko nan tema
let us start our session by giving the attendance to the court
bikan ka tuko mongor kan shoot and court la shoot nan ten content when mo okay
honorable court my lord denga shula dia General Minister of Justice, the President of the Investigator, the complainant, and the prosecution team in present. Thank you.
Then actually Ramker team and Chalke prosecution team. Prosecution team can even call them
Good morning, Your Lordship.
Yeah.
Just wait.
Amuda kuka la kwa le tegna attendance miterami momite jor mechanic open wenamo then by the kula ngach not yet can road in area like but kwa kemna attendance can it in content ten wenamo you know
Of Advocate Gary Raimondo Lienge Lobate, the lead defense team, in the presence of my learned colleagues, Advocate Kurlwal Kur,
Present.
Yeah, in the presence of Advocate Kurlwal Kur, Advocate Anis Tombe, Advocate Deng John Deng, Advocate Ornyang Kir Ornyang,
ngoda wukan go adio ja la netin content kwa na me broadcast la ngada dien jaga
representing women in our side.
La microphone dien jaga so cha joja go
Thank you.
In the presence of the 8 accused persons, 8.
kan dang badek ner konen cha gwain kan dang badek.
Thank you.
Rama Pyra Gwaza me jen lead defender pin Dr. Machar ne contin tin kwa Dr. Machar kwa defend. Ngoda wa magar kan shoot ken pin gwasma so dio jabu konta bo dolbon nyambu jatam bana jeling no ngoda wukan ka magor ken dio jen wo wala dio ja bana dio jabu konta mo go amban ling dio ja ka janame dio jabu kan jodin kan kula tup tama right now not yet kan jodin kan tup so kan jodin kan tup yon then dio jabu konta kan knowledge come down board a lot but right now not yet so ko kan talk bana man to ban yangach remember 30 minute dio ja ke ta welcome 00 dong bana jen
I think the session is today is the decision on the 2 objections, the one of the defense and that of prosecution. Thank you.
and wala ke 2 objection Carolian balada.
Okay, good morning. Let's go direct to the decisions, and I'm going to read it out.
Okay. Okay.
On the 1st of September 2025, the President of the Supreme Court and the Chief Justice of the Judiciary of South Sudan constituted this special court to try criminal case number 1533/2025 for Nasser incident, March 2025, against accused person under sections 48, 50, 52, 61, 62, 65, 64, 65, 66, 67, 70, 71, 72, 75, 76, 206A and B, and 239 of the Penal Code Act 2008, and also sections 15A, B, and 16 of Anti-Money Laundering and Counter-Terrorism Act 2012, amended. On 22nd September 2025, the defense presented to the court an objection, all preliminary objection. The title, Objections on Lack of Jurisdiction of the Special Court to try the first Vice President and the 7 others accused persons. That may be summarized as follows. Number 1, supremacy of revitalized agreement. And number 2, jurisdictional and procedural objection. Number 3, counter objection on the appearance of private advocates as part of the public prosecution attorney's team. As for the supremacy of the RI revitalized agreement, the defense cited Article 8.3 that says this revitalized agreement shall take precedence over national legislations and existing agreement to the contrary, and in the event that the provisions of national legislations or of previous agreement conflicts with the terms of the agreement, the provisions of this agreement shall prevail. And that the revitalized agreement 2018 provides under 5.3.1.1 for the establishment of hybrid court for South Sudan. This court is independent and established by African Union Commission to investigate and prosecute individuals bearing responsibility for violation of international law and applicable South Sudan laws. Committed from 15 December 2013 through the end of the transitional period. Nasser incidents is a ceasefire violation, and therefore it falls within the jurisdiction of the hybrid court. Article 1.7 of the revitalized agreement 2018 that should be adhered to. Read together with Article 5.3.1.2 and 5.3.2.2. In addition to Article 201A, 7, A, B, and D of the Transitional Constitution 2011 as amended. Furthermore, the defense mentioned that Article 9, 3 of the Transitional Constitution of the Republic of South Sudan 2021 as amended provides that all rights and freedoms enshrined in international human rights, treaties, conventions, and instruments ratified by or acceded to by the Republic of South Sudan shall be an integral part of this bill. So, trial of the accused persons disregard and alter-verse and unconstitutional. The defense also raised an issue of jurisdictional and procedural objection on the constitutional immunity of the first vice president, citing Article 103, 104, 2 of the Transitional Constitution of the Republic of South Sudan, 2011, as amended, read together with Rules 62 and 63 of the Transitional National Legislative Conduct of Business, 2013, as amended, 2021, that provides that the first vice president shall not be subjected to criminal proceedings while in office, except upon removal of immunity by 2/3 majority of all members of the National Legislative Assembly, and in accordance with the Rule 62 and 63, that provides that the provision of 62 shall, with the necessary modification, apply in respect of the first vice president and vice presidents. This raises questions as to when does court become competent. It is when it is properly constituted as regards yes, it is properly constituted. The subject matter is within the jurisdiction of the court, and case is put before the court based on due processes of law. This court is defect in its competency, since the President of the Supreme Court has no power to establish it before to establish it has no power to establish it before provisions of the Transitional Constitution 2011 as amended, Article 103, 104, 2, and provisions of the Transitional Legislative Assembly 2013 as amended, 2021, Rule 62, 63 are adhered to, and also lack of resolutions that shall have been passed by the 2/3 majority of members of Transitional National Legislative Assembly as amended. The arrest and detention of the accused were carried out without due process of especially lifting of the immunity of the first vice president. And therefore, on the proceedings are unconstitutional, unlawful, and void. The accused person shall be immediately released, plus any other relief deemed fit by the court. The response of the prosecutions may be also summarized as follows. Number one, that provision of revitalized agreement 2018 and transitional constitution 2011 amendment number 6 2020 limits jurisdiction of hybrid court to international law crimes and crimes under relevant South Sudan laws, including gender-based crimes and sexual violations, when and if established. There is no conflict between the revitalized agreement and national law in this case. The two are distinct. Number two, that it is only the president who is immune during his or her tenure of office, according to Article 103(1) of the Transitional Constitution 2011, Amendment number 6, 2020, and Rules 62 and 63 of the Transitional Legislature, Conduct of Business Regulations 2013, Amendment 2021. They deal with the removal if the Vice President and not trial, dealing with the removal of the Vice President and not trial of the same, since that does not override provision of the Constitution. Number three, that according to Article 123A of the Transitional Constitution 2011 as amended, the Judiciary Act 2008, Section 7F, and the Code of Criminal Procedure Act 2008, Section 16(4), give the President of the Supreme Court powers to constitute a special court to try any person accused under Chapter 5 and 6, inclusively, of the Penal Code Act 2008, and a written order for establishment of a special court as required under Section 44 of the Code of Criminal Procedures Act 2008. Therefore, the special court has been duly constituted in accordance with the law, and it follows that the court is legitimate. Number 4, that the Minister of Justice has power under Section 45 of the Ministry of Legal Affairs and Constitutional Development Organization Act 2008 to engage any advocate outside the ministry whenever necessary. Each party stood its position in its response and comment to pleading of another. And according to that point for discussion and determination may be summarized as follows. Number 1, supremacy of the revitalized agreement 2018 as embodied into the Transitional Constitution 2011 Amendment number 6, 2020. Number 2, President of the Supreme Court has no power to constitute a special court to try national incidents crimes. Number 3, immunity concerning the first Vice President who was not lifted when he was arrested. Number 4, a special court established by the President of the Supreme Court is unconstitutional. Number 5, that private advocates who are on the side of or within the public prosecution have no legitimacy and should be sent away. And the 2 advocates within the defense teams lack or have no license and should be told to go outside the court or sit with the audience over there. Now, it is evident from the submissions that main points for the determinations are to be discussed as follows. Number 1, reading warrant of the establishment of this special court and argument of defense and prosecution, the court believes that there is no overlapping of jurisdiction between its competency and the one of hybrid court, for it tries offenses committed in Nasser incidents in March 2025, and that hybrid court have jurisdiction within with respect to genocide, crime against humanity, war crimes, and other serious crimes under international law and relevant laws of the Republic of South Sudan, including gender-based crimes and sexual violence, as provided for in the Transitional Constitution of the Republic of South Sudan, 2011 Amendment number 6, 2020. The Constitution made it clear that the hybrid court shall be independent and distinct from the national judiciary in its operations and shall carry out its own investigations. The hybrid court shall have primacy over any national court of the Republic of South Sudan of course, when a conflict of law arise. So, the High Court has jurisdiction to investigate and prosecute in respects with individuals who violated applicable laws of South Sudan, which are relevant according to Article 5.3.1 and 5.3.214 of the Revitalized Agreement of 2018. It is obvious now that those applicable laws of South Sudan and its other relevant laws have not been identified or named in the Revitalized Agreement.
Dio Jashi Narudin, Dio Jachatika Riek, Naka sauce, was done to Wotan, so Dio Jabukudunjo. Could it Quancamagwasame, while we are waiting? Barang aja no katin kontin gue kanu la duir kana goy ki do badan de rek machar de je yen ke je ki charge de yen ke je do badan de je luka je ki charge de luka je ko ai kon dial no nena la code me a special court me shall establish a president dio je kanetin kontin shina me chi kana realeka no dong ba luka me ba je lu ngode ben be je no ye ngode kan kana ben mi chi kana to ko right now kan ni yat pin agwanu de me ngum lero de dio je bi kana yat pin tama ko te mi kana nyodo ni na wena men go ne na kani mi sharam kel cha je diran wena mo no ram mo jeram dara de kaf dir ngai kona okay chana
on the resolution of the conflict in the Republic of South Sudan in 2018. It follows that failure of the Revitalized Agreement itself to specify those applicable South Sudan laws and relevant laws of Republic of South Sudan made it difficult to understand the specific jurisdiction of the hybrid court itself in regards to the laws of the Republic of South Sudan, which fall within its jurisdiction, domestic laws. The hybrid court for South Sudan have not yet been established, and it is not clear when it will be established. National courts of South Sudan are operating and exercising their constitutional mandate according to the provisions of Article 122, sub-article 1 and 2 and 4 of the Transitional Constitution 2011 as amended, as long as they have not been suspended or withheld from doing their work by the hybrid court, which is in actual fact is not existing, since the national and hybrid courts are independent according to the provisions of the Article 5.3.2.2 of the Revitalized Agreement 2018, the special courts enjoys jurisdiction to try this case according to the Constitution 2011 as amended. Number 2, as for the jurisdiction and competency of the President of the Supreme Court to constitute a special court to try national incidents, offenses, the law is clear that he or she has the power, bearing in mind the separation between hybrid court and national courts, as stated above. To explain, the President of Supreme Court of the Republic of South Sudan established Nasser Special Court according to provisions of Article 122, 4, 126, 2, G, 3, and 127, 1B of the Transitional Constitution 2011, in addition to the provisions of Section 16, 4, and Section 44 of the Code of Criminal Procedure Act 2008, and Section 11, 3, 7F of the Judiciary Act 2008. Therefore, the court has jurisdiction and competence to try the accused persons, since the wordings in the Revitalized Agreement 2018 and Transitional Constitution 2011 Amendment number 6, 2020 says that the word that from 15th December through the end of the transitional period is not meant to hold back states' hands in addressing crimes, even if the hybrid court is active. The national courts have the jurisdiction and powers to prosecute offenses in the territory of the Republic of South Sudan. Therefore, it is the evidence that is the sticky yard to prove whether the subject matter of the trial belong to the hybrid court or national court. Number 3, concerning the lifting of immunity of the first vice president raised by the defense based on Article 103, 102 of the Transitional Constitution 2011 Amendment number 6, 2020, and Rule 62 and 63 of Transitional National Legislative Assembly Conduct of Business Regulations 20 Amendment 2021, which provides that the first vice president should not be subjected to criminal proceedings while in the office, except upon proper removal of the immunity by a resolution passed by 2/3 majority of all members of National Legislative Assembly. The prosecution replies to these claims in their submission. In pursuant of Article 106, 106, 104, 103, and 102, the Transitional Constitution 2011 as amended, and provisions of 62, 63 of the National Assembly Board of Business, Article 1031 confers constitutional immunity upon the President of the Republic of South Sudan only.
Article 4
of the Constitution
Midong de machar de look again special code sha ya pinya kana ke de look hybrid code ko lo kwente ko ne sha lat ban ga ni yo gwa dan ba jo ya pinkin an yen na ke
of the first vice provision did not expressly or directly mention immunity of the first vice president and other four vice presidents. As for the provisions of rules 62, 63 of conduct of business stated above, deals with impeachment of the President of the Republic. And Rule 63 of the same deals with the removal of the first vice president and the four vice presidents. The two rules cited by the defense do not talk about constitutional immunity of the first vice president, because the constitutional immunity is created or granted by the Constitution as the supreme law of the land in the hierarchy, according to provisions of Article 3(1) of the Transitional Constitution 2011 as amended, which reads, this Constitution derives its authority from the will of the people and shall be the supreme law of the land. It shall have a binding force on persons, institutions, organs, and agencies of government throughout the country. Therefore, provisions of the National Assembly Code of Business 2013 as amended is a subsidiary legislation. It governs conduct of business of the Assembly, which is subordinate to the Constitution 2011 as amended, and therefore it doesn't create or grant constitutional immunity to anybody in the country. On the contrary to the Constitution, for the above mentioned reasons, the first vice president does not have constitutional immunity. According to the provisions of the Transitional Constitution. Therefore, the objection is rejected. Number 4, whether the special court established to try Nasser incidents is unconstitutional or constitutional. The Transitional Constitution 2011 Amendment number 6, 2020 says Judicial Services Commission shall undertake appropriate judicial reforms and restructuring of the judiciary during the transitional period. The structure of the judiciary remains as it is under Article 123 of the Constitution above. Other courts and tribunals are part of the structure of the judiciary as provided for in Article A of the stated Constitution. Section 16 of the Code of Criminal Procedure Act 2008 provides for special courts, and it's specifically subsection 2 of the above provides that the President of the Supreme Court may convene a special court to be presided over by a High Court judge or any other senior judge, to be assisted by 2 assessories for the trial of tribal or sectional conflict and dispute involving capital offenses. Reading those provisions with the Judiciary Act 2008, we can say this special court for Nasser incidents is constitutional and therefore has the competency to try the case as stated previously. Number 5, advocates here and there. Both parties to the case objected to certain advocates found within this or that team. Prosecution and defense. Prosecution's objection is that Advocate Deng, John Deng, and Warnyang shall not be allowed to be within the defense team because they did not renew their license according to the law. Advocate Act 2013. Failure to renew the license at the end of January every year, the license shall be deemed to have been suspended. The defense is not denying that, but saying they were deliberately denied to do so by the Bar Association. Since advocates are tasked to defend legal and interests of their claims, to prevent injustice as guaranteed in the national and international instrument, the defense prays the court to reject prosecution objection, considering the period from January, from the end January up to now. It is a long time. The advocates in question would have tried possible means to renew their license, including going to the court to settle the matter. Appearing before courts without valid license violate Section 26 of the Advocate Act 2013. It follows that joining defense team without informing or even taking permission from the court may not be upheld, since it is a constitutional requirement under Section 136(2) of the Transitional Constitution 2011 as amended, among others. The advocates shall observe professional ethics. The only way now for them to rejoin the team is to remedy their position by using Section 102 of the Code of the Criminal Procedure 2008 and seek out sanction of the President of the Supreme Court to appear before this court. As for the private advocates with the prosecution team, defense objection has no merit, simply because it is obvious from Section 45 of the Ministry of Legal Affairs and Constitutional Development organization that the minister may engage, advocate, or make use of legal expertise from outside the ministry whenever necessary. This is his or her discretion powers. Therefore, the objection is refused and the decisions or the orders of the court are as follows. Number one, objections of defense teams are overruled. Advocates Deng John and Kiir Warnyang are ordered to leave defense team and seek sanction of the President of the Supreme Court to return back. Private advocates within the prosecution team are allowed to continue. Thank you. Sit down and finish. And after this, the disposal of these two objections, now we proceed to listen to the prosecution's one witness, who is the investigator.
Family door cha deny kan diar katin konte shalat gwa sedan te bena eyewitness ni kata dana shikori to ko ja
may it please this court, I would raise a procedural issue under section 224 of the Code of Criminal Procedure. And the procedure issue is that we are, as a prosecution, supposed to provide before this court our prosecution opening speech.
You are correct. Please proceed.
Thank you, my lord.
First by President Chalaro immunity constitution doing reply peace agreement kan tele riek machar tele immunity kan woide mado de wo chikan nyogala de wona na kani Nasir incident na kani chi violation of ceasefire katara ni kala ke jamte code motive long nyogi kala de wona na two advocate ka Dr. Machala defend lawyer can chaga ka chong immediately amen me chikan renew so chana to go chana iling so chiri al chiga to kala no bugo move on.
The advocates who have been sent to go, please let them go, and you are advised that you go to the Chief Justice and get his sanction and come back. We are very clear, all right? Thank you. Please go.
Chiga kai kuka la kai kana chiga na tura na ne de kontila defend lawyer.
Thank you, my lord. Honorable Court, this is the prosecution opening statement of speech. In this case of Republic of South Sudan versus Port Kang Chol and others, criminal case number 1533 of 2025. Honorable Presiding Justice and distinguished members of the bench.
Don't be running. Just give us a chance to write. Yes. Opening speech.
This is a prosecution opening speech. We are going to give you copies of the same, and I will try to be as slow as possible as well, my lords. So this is the opening speech. Republic of South Sudan versus Port Kang and others. Criminal case number 1533 of 2025. Honorable Presiding Justice and distinguished members of the bench, with due respect and on behalf of the Republic of South Sudan, allow us to present this prosecution opening speech. On the 3rd through the 7th of March 2025, in Nasir County, Upper Nile State, the people of South Sudan and the world witness the gravest crimes that strike at the very heart of our constitutional order, endangered our national security, and traumatized and inflicted immeasurable suffering on the people of South Sudan. The government military garrison in which Yardio, Nasir was attacked and overrun by the White Army militia. The government forces that surrendered on their own and those that surrendered on the persuasion of the fifth accused person, Dr. Riek Machar, including the late David Maju, who was to be evacuated by a UN helicopter. Those injured and those captured alive were rounded up and executed at point blank. The dead were dragged around and others dumped into the river and others left to rot where they were executed. My Lord Justices, on April 20th, the South Sudan People's Defense Forces, SSPDF, regained the control of Nasir Town and Wichyardio military garrison. At Wichyardio garrison, they were welcomed by the dry bones of their slain comrades. An apocalyptic scene comparable to the biblical phrase of Valley of Bones. But here, my lords, it was a barbed wire garrison, a plain land of bones overlooking the silent and grieving river. The prosecution stands before you today on behalf of the people of the Republic of South Sudan to seek justice for these heinous crimes committed by the accused persons. My lords, Justices, this case is about individual criminal acts or omissions or responsibilities of the accused persons. I emphasize individual criminal acts or responsibility of the accused persons. The accused persons are namely Port Kangchol, Lieutenant General Gabriel Droblam, Mampal Duor, Garawich Lampoj, Dr. Riek Machar, Brigadier General Camilo Gatmichael, First Lieutenant Mading Riek Yak, and Lance Corporal Dominic Gatgok Riek, who are present before you here, and others who are at large, namely Lieutenant General Peter Tokchuo Luak, Major General Lienge Cholkuch, Major General Peter Ruach Wibiem, Lieutenant General Ye Dak Wiu, Major General William Dengbom, Kang Makana, Major General Kong Miang, Kwang Terjes, Garawich Liam, Biel Wiu, James Galwak Liu, Brigadier General Hogdor Chuol, and Pal Mai Deng. My Lord Justices, investigations were conducted of over 100 people, and the rest were released, and only these were the ones the prosecution has presented before this court to have been found culpable in the criminal acts that they are being charged with. In due course, Mr. Presiding Justice and distinguished members of the bench, the prosecution shall seek the indulgence of this honorable court to permit the prosecution of those absent and at large in absentia. The honorable Presiding Justice and distinguished members of the bench, the incident in Nasir in March 2025, characterized by brutal mass murder in cold blood, inhumane treatment, and total disrespect of the dead, and total disregard of the laws of South Sudan remains unforgettable and regrettable stain in the conscience of this republic. My Lord Justices, the prosecution will demonstrate that these were not spontaneous attacks, but actions of well-organized, well-financed, brutal criminal scheme. A criminal scheme carried out by the accused persons as they incited, organized, abated, financed, and weaponized a militant group, the so-called White Army, to target SSPD personnel, civilians, and undermine the government. My Lord Justices, the prosecution will avail evidence that the White Army did not act independently. They were under the direct command of the fourth accused person, General Gabriel Droblam, Major General Lienge, who is at large, and the fifth accused person, Dr. Riek Machar, and financed by the first accused person, Mr. Port Kangchol, and Mampal Duor, the third accused person. The attacks by the White Army were planned, funded, coordinated, and commanded by some of the commanders of SPLA-IO. We emphasize some of the commanders of SPLA-IO. The commanders in Juba coordinating the assault were Lieutenant General Gabriel Droblam and Major General Lienge. And on the ground in Nasir, the SPLA-IO officers commanding the White Army were namely the late Torgel, Thon, Kang Makana, who is at large, Lieutenant General Peter Tokchuol, Brigadier General Manpinj Pal, Brigadier General Peter Palmut Yaj, Bol Doyak, and Major General Kong Muyang. This means the attacks were executed under the direct orders of the fifth accused person, who is the commander-in-chief of the SPLA forces. The evidence the prosecution will present will establish this clear and undeniable claim and the chain of command. It will demonstrate that the militant White Army operated under the direct command and influence and the strategic direction of the accused persons before you and those at large. My Lord Justices, there is a false narrative that this trial is a political witch hunt against the fifth accused person, Dr. Riek Machar, and the other accused persons. Contrary to this claim, my lords, this trial is about the rule of law. It is about giving justice to the victims. It is about having a closer to the victims, fighting impunity, and setting a new departure that crimes must be punished, that there must be a new chapter of accountability for all, regardless of status. Albeit this, it is inversely an opportunity for the accused persons as well to clear their names. In this commitment to the rule of law, my lords, the accused persons before you are presumed innocent as per our Constitution until found guilty by this competent court. It is to this commitment that this trial is open to the public. Further, my lords, it is to this commitment that the accused is duly represented by a competent defense team. And the Republic of South Sudan is willing and in position, given the nature of the offenses herein, to assign.
Mlingen magwas me medan e chito ka jan shane non tam alo cha Dr. Riek Machar Kennedy ala konti kel cha la ru ken take te riek chikan lat gwas mi dio ya chi achu na chia kaling enono ka ta dan going ken keje ko cha chalan u en code mi special code me take lwanki take chonko ba gade be look so jen dan le ro den tamen menere yuch
terrorism, terrorist financing, mass murder, destruction of protected property, treasury, attacks on United Nations personnel, unlawful seizure of a military garrison, and participation in an organized criminal act. These charges, my lords, are brought under the Penal Code Act 2008, the Anti-Money Laundering and Counter-Terrorist Financing Act 2012 as amended in 2024, the National Security Service Act 2014 as amended in 2024, the SPLA Act 2009 as amended in 2020, and the Geneva Convention Act 2012. The prosecution will provide evidence proving beyond reasonable doubt that the accused persons committed the said crimes. And that the crimes are, 1, a crime of treason. Instead of paying allegiance to the Republic of South Sudan, the accused persons waged war against the state with intention to overthrow the constitutional government contrary to sections 64, 65, and 66 of the Penal Code Act. That the accused persons engaged in terrorist acts. The accused persons committed violence with the intention of causing forcible resistance to the government and to the defense forces and any lawful agencies, as well as possession and using dangerous weapons, contrary to sections 67, 70, 71 of the Penal Code Act. That the accused persons engaged in terrorist financing, the accused persons collected and provided funds with the knowledge that they would be used for terrorist purposes, contrary to section 14, 15, and 16 of the Anti-Money Laundering and Counter-Terrorist Financing Act 2012 as amended in 2024. That they committed mass murder. The accused persons abated the brutal and inhuman killings of armed SSPDF and wounded personnel, including the late Major General David Major Dak, the commander of SSPDF in Nasir, a UN personnel member, and 257 SSPDF personnel in Nasir, in violation of the Geneva Convention and the Penal Code Act, sections 10 and 206, respectively. That they committed as well destruction of protected property by damaging UN-marked helicopters, destruction of military equipment and civilian assets, contrary to Section 67 of the Penal Code Act and the United Nations Convention on the Safety of United Nations and Associated Personnel, 1994. And that they committed treachery by consciously giving confidential information to the SPLA-IO commanders on the ground and in Juba, and withholding vital information from the SSPDF command, contrary to sections 64, 1, F, and G of the SPLA Act 2009 as amended in 2022. My lords, in terms of evidence, the evidence will point a picture of calculated violence that extended beyond military targets It will detail gross violations of the Geneva Convention, including desecration of the dead and persecution of innocent civilians and UN workers. The prosecution will present a layered evidence strategy, beginning with testimonial evidence that will come from survivors, eyewitnesses, and protected witnesses who will recount the attacks, the planning meetings, and the consequences they endured. The prosecution will provide documentary and physical evidence like signed operational orders and autopsy reports. The prosecution, my lord, will provide digital forensic evidence like call records, WhatsApp communications, preserved and authenticated in compliance with international standards and international evidentiary standards. The prosecution as well will present expert testimonies from forensic pathologists, from digital forensic specialists, from military experts that will assist this honorable court in understanding the technical aspects of these crimes. This evidence will be presented chronologically, from the planning to the funding to execution to the aftermath, ensuring that each strand corroborates the other and eliminates reasonable doubt. My lords, the prosecution will meet this with the independent corroboration of witness statements, forensic and biometric evidence, authenticated through metadata, hash measures, hash values, and expert verification. In terms of procedural standards, my lords, the prosecution will assure the court that every exhibit is supported by an unbroken chain of custody. Vulnerable witnesses will be protected, including through in-camera testimony when necessary. In conclusion, my lords, this trial is a testament to our nation's unwavering commitment to the rule of law and to breaking this cycle of violence and impunity. The accused persons have been informed of their rights and their right to fair trial. We operate in a strict adherence to our constitutional standards and our obligations under international law. This trial, my lords, is about accountability, justice, and the rule of law. The evidence will prove that accused persons deliberately conspired to wage war against the state, terrorize civilians, and undermine the peace and security of South Sudan. At the conclusion of this case, my lords, notwithstanding the presumption of innocence of the accused persons before this honorable court, the prosecution shall respectively request conviction on all principal charges and the imposition of sentences proportionate to the gravity of these crimes, consistent with South Sudan laws and international standards. Allow me, my lords, to return the mic to you, if any, for the defense team to exercise their right of reply to our statement, and thereafter to the investigator who shall journey us through the process of demonstrating the evidence that shall be demonstrated before this honorable court to prove the charges against the accused persons. With this, my lords, justices, the prosecution remains appreciative of your patience. I end. Thank you.
Gwa shikarwacha ka ta dane shi ngwano den lat keje tai kore to keje shikanten ngai kon ko de kan galat ban ba shikan kalat na ana chana
the next step is that we go to hear the first witness.
They have the defense?
No, they don't have. The law is clear.
Can I tell a different team can begin Latin not only can I clear? You can be one of the point a judge Gaga point. Too much.
Thank you, my lord.
Excuse. You know, it's very, very good. You know, while we're going to start, please, if there are witnesses of both parties within the audience in the court are ordered to go out. If there are witnesses here in the court, let them go out. This is very important because if we discover that there was a witness inside the court listening to all these pleadings. We may not allow him to provide his statement. And also, let me take this opportunity to remind the media, those who are reporting, please stick to the rules of reporting, journalistic reporting. You should not go and start trying to pass your opinions or trying to analyze the facts that are given in the court. Please adhere to the law, to the provision of the law, domestically and internationally.
Can I go Jokane Dial no tell me ba Martin Kamishor lad Guasamani, can I dial back a deal lat Qatar and a Shagalat Kaja Guasamani? Of course, dear Jatella Medong de Latin course, Jagatunku and Bonnie already. So we'll just listen to all these things. Court charge open publicly loader and there which but charge no don't tell them commander to
أنا داير نقول شنو أي زول بيعتبر نفسه شاهد للدفاع شكرا.
Now, let us begin with the first witness of the prosecution. So there is no reply, according to the law, that the defense, no excuse, please sit down. Let us start. Excuse. Sit down until I give you.
My Lord, as we pass decision on the objections which were noticed by the two parties, we in the prosecution team in the position to request Your Honor that this session to be adjourned for tomorrow for verifications, all the exhibits and evidence which in our side to be presented by the investigator.
Thank you. The defense, what is your reply? Do you have any objection?
Thank you, my Lord. First and foremost, before I engage to respond to our colleagues in the prosecution, I'm praying from Honorable Court to avail us with a copy of the decision read to us for some minutes. We need a copy.
The opening speech is not given to you?
The ruling of this Honorable Special Court for our objection on point of law. We need a copy.
It's okay. You may be allowed to be given copy. Whatever you want. But what is your response to the request for the adjournment for tomorrow?
Before I respond to the prayer of our colleague in the prosecution to adjourn this session, we are governed by Act Section 224 of the Code of Criminal Procedure Act, specifically 224 subsection 2, which allow us as defense of the opening speech, we are given also the legal right hearing the defense, evidence of defense to respond to what the prosecution have stated. We are ready. My Lord, Your Lordship, subject defense response to the public prosecution opening speech, we act for and on behalf of the accused, His Excellency Dr. Riek Machar, the first Vice President of the Republic of South Sudan, Good Kang Chol, Lieutenant General Gabriel Dub, Mam Pal Dor, Gadwich Lampoj, Brigadier General Camilo Gadmal Kel, Madingiar Yak, and Dominic Gadrog Riek, respectively. We submit this response to the opening speech delivered by our colleague, the public prosecution, as follows. I want to bring the attention of our colleagues that in their opening speech, they just gave us a conclusion without giving us the facts. They have used command, influence, who command who, and who influence who.
Objection, my lord.
Yes.
My lords, based on the section cited, section 222, subsection 2B, that deals with the prosecution opening speech, there is nothing as a right of reply. If it's referenced in subsection C, it talks of reply of the accused to the prosecution. That is a state that we have not reached to, because we are supposed to get into the statement of the inquirer, who is the complainant, and the statement of the complainant, if any, and the discussion of the same. What I was expecting is, my lord, based on our procedure, this is a special court. When the investigations were completed, the investigator and the public prosecution took the evidence to the court. But given the sensitivity of the matter, the court then, before the establishment of this court, the Office of the Chief Justice advised that given the sensitivity of these evidences, it should be kept by the prosecution and only be availed before this honorable court on the start of the prosecution case. So what we are expecting, or what we are praying for this honorable court, is we sought an adjournment to allow the prosecution and the investigator to submit to this honorable court the evidence that is available. Because we cannot give it to the court, since the Chief Justice had advised that the special court had not been established, and therefore we must come and submit it to the special court. And we request for this, my lords, in the interest of justice and following our rules of procedure. Thank you.
Yes.
Your Lordship, it seems that the prosecution have forgotten about natural justice. And natural justice, the element of natural justice are two. One, odi altrum patrum, which means do not condemn somebody unheard. Second, nemo judice impropera posa, which means a monkey should not determine the affairs of the forest, which means rule against bias, which is part of Article 19 of our Constitution. The right to be heard is enshrined in the Universal Declaration of Human Rights, 1948. It's also enshrined in the International Covenant for Civil and Political Rights of 1966, read together, International Covenant for Social,
Objection. Objection, Your Honor.
Please, let him continue.
Are you forgetting our rights?
Please, continue.
We have spoken, and this is my time to talk.
It's okay. Please shorten your response.
Thank you, my Lord.
Yes.
My colleagues, Your Lordship, the prosecution alleges that our clients and 8 accused are guilty of serious offenses under Chapter 4 and 5, Section 206, 239 of the Penal Code, read together with Section 15A, B, and Section 16 of the Money Laundering and Counterterrorism Act 2012 as amended, read together with all the sections mentioned in the charges. To succeed, the prosecution moved from must prove beyond reasonable doubt that the accused person committed each and every element of the alleged offenses unless and until the prosecution discharged that burden, the burden of proof lies on them to certification of this honorable special. The presumption of innocence must prevail. First and foremost, Your Lordship, and before we indulge into the fact and the law applicable, we would like to emphasize on the role of a prosecution attorney, because criminal law or penal court involve a contest between a state and accused person. It is imperative that both sides are represented by competent and ethical advocates or attorneys. The primary duty of lawyers for state prosecution and the accused or defense is to assist the court and the process and not to their respective clients as such. Thus, both sides have essentially similar obligations, although they come to their task from different perspectives. Your Lordship, a prosecution represents the state, not the victim. His or her duty is not to secure conviction at all costs, but to ensure that all the evidence fairly and accurately adduced before the court of law. Your Lordship, a prosecutor is the Minister of Justice who represents the government in the public prosecution according to provision of Article 135, Clause 3 of the Transitional Constitution of the Republic of South Sudan, 2011, as amended. The prosecutor principal's role is to assist the court to arrive at the truth and to do justice between a community and the accused person according to law and the dictates of her. A prosecutor is not entitled to act as if representing private interest in litigation. A prosecution or a prosecutor represents a community of South Sudan, and not any individual and sexual entity. A prosecutor acts independent, yet in general public interest. The prosecutor interest is to be understood in that context as in historical continuum, acknowledging debts to previous generation and obligation to future generation. Your Lordship, in carrying out that function, it behoved him neither to indict nor on trial to speak for conviction except upon credible evidence of guilt, which credible evidence means believable evidence, reliable evidence, truthworthy evidence, evidence acquired according to law, not unconstitutional evidence or illegal obtained evidence, which will submit to this honorable court in due course. Let me repeat again. In carrying out that function, it behoved him, the prosecution, neither to indict nor on trial to speak for conviction except upon credible evidence of guilt, nor to do even a little wrong for sake of expediency, or to pick any person or please any power, not to be either gullible or suspicious, intolerant or overplanned, as we have realized from our colleagues there. In the firm and abiding mind to do right to all manner of people, to seek justice with care, understanding, and good confidence. They should not be biased to the government. They should be biased to the people of South Sudan. Restore justice in this nation, this beautiful nation of ours. Your Lordship,
My Lord.
it cannot be.
My Lord.
Thank you.
Yes. Let my learned colleague to stick on our opening speech, not to make reflection of what he is in mind, criticize the persecution. This is not the time for him. Thank you.
It's okay, sit down. Please, please.
Your Lordship.
Doctor, try to summarize, because we have written...
Mine is only 5 papers, and we have done 2, remains 3.
Try to stick to their...
Your Lordship, it cannot be overemphasized that the purpose of criminal prosecution is not to obtain a conviction. It is to lay before a court credible evidence, relevant, related, connected, and linked with the facts. One of the ingredients of the elements of the crime, which all of us, we know in this room, actus rea, mens rea, and causa show. We need our colleagues there to stick to these 3 elements, ingredients of the crime. Mens rea, actus rea, mens rea, and causa show, which means physical act, criminal guilt, and connection between the act and the deed and the result. Your Lordship, lawyer has a duty to see that all available legal proof of the fact is presented. It should be done firmly and pressed to its legitimate strength, but it must all be done fairly. The role of the prosecution excludes any notion of winning or losing. His function is a matter of public duty than which in civil life there can be none charged with greater personal responsibility. It is to be efficiently performed with an ingrained sense of the dignity, the seriousness, and justice of judicial proceeding. Your Lordship, furthermore, Lord Macmillan, a Lord Advocate General in Scotland, and a member of the Judicial Committee of the House of Lords of England.
Please, Giri, why don't you just give us the paper and then we gain the time instead of...
I'm being. So this Lord says, we, in the discharge of his office, the advocate has a duty to his client who are here, a duty to his opponent who are there, a duty to the Honorable Court, a duty to himself, to myself, to ourselves, to respect this Honorable Noble Court, and a duty to the state, our country, the Republic of South Sudan. We are here for that. Your Lordship, the accused person prior to their arrest were subjected to politicized media campaign, outrages by ministers, politicians, and senior officers. In that campaign, explicit accusations were broadcast against them. The media broadcast against them to the public. This conduct amount to unlawful and prior conviction of our accused and a blatant violation of the constitutionality guarantee presumption of innocence, which is stipulated in Article 19, Clause 1 of our beautiful Constitution, read together with Section 6 of the Code of Criminal Procedure 2008, Laws of South Sudan. The accused is innocent until it is proved beyond reasonable doubt And for our colleague, let me tell you from here, what is the meaning of beyond reasonable doubt?
Gary, please,
Let me conclude.
Yes.
Moreover,
You just try to conclude.
it
please.
is just only 3 lines. Moreover, the defense records are...
Excuse me, Dr. Giri. You must know that Section 224 doesn't give you the right to respond. And we allow you to do that simply so that you enrich the procedures. Please try to summarize. Otherwise.
Thank you. I want to remind this honorable court that South Sudan belongs to common law and judges always make law in the absence of procedural fair. We have to do that to our country. Moreover, the defense records that the investigative authorities proceeded to arrest, interrogate unlawful search, and charge the accused person before their constitutional immunity had been duly lifted, and only thought to cure this defeat respectively. This violates the principle of legality, as a principle firmly recognized in our jurisprudence that what is built upon illegality remains invalid. It is null and void, ab initio, ad limine, from the beginning. Any such without due process of our Code of Criminal Procedure to our clients here are considered to be null and void, ab initio. Your Lordship, in addition, this case has placed the government in a position of embarrassment. It has been brought forward without proper official rights and without the request procedural foundation. This has left the public prosecution exposed to the extent that it risks withdrawal. This scenario mirrors a well-known precedent in which their late colleague, distinguished counsel, our late colleague, Charles Deng, our brilliant lawyer of this country, who passed on. He rejected to represent the government in the case of Asma Mahmoud, Mohamed Taha, and others versus government of Sudan in is published in the Sudan General Report 1986, where it was affirmed that the prosecution cannot sustain a prosecution in the absence of proper legal foundation. Honorable Justice of this Honorable Special Court, justice is neither proclaimed from political podiums nor declared in security offices. Justice is dispensed in the courtroom, beautiful courtroom like this, such as this special court under the rule of law. And the rule of law, our professor, Albert Van Dicey, has come with his book about that.
I give you 2 minutes to finish your speech.
Thank you. Your Lordship, a matter of fundamental importance arises in this proceeding, namely the manner in which the prosecution intends to establish that accused person is standing before this special court are responsible for alleged crime, of which crime scenes in Nasir, in the Upper Nile state. It is undisputed fact that the said location is situated at a distance approximately 712 kilometers from the city of Juba, where all these are here, and Nasir is far. How they manage, they fly up to there and come. We don't have transport from Juba to Nasir. We don't have the road. How they manage to go there, the burden of proof lies on he who alleges to prove the case beyond reasonable doubt. Your Lordship, the accused person has been detained since March 2025 up to 21 of September 2025 in a clear violation of their constitutional right. A person arrested by the police as part of investigation may be held in detention for a period not exceeding 24 hours, and if not released on bond, to be produced in court according to provision of Article 19, Clause 4 of our beautiful Constitution of the Republic of South Sudan. Number 2, every person shall have the right of a fair and speedy trial, and justice shall not be delayed pursuant to provision of Article 122, Clause 5, Paragraph B of the Constitution, our Constitution. Read together with the provision of Section 6A of the Code of Criminal Procedure Act 2009. Number 3, every accused person is presumed innocent until his or her guilt is proved beyond reasonable doubt in accordance with the provision of Article 19.1 of the Transitional Constitution 2011 as amended. Read together with the provision of Section 6B of the Code of Criminal Procedure. Number 4, no punishment shall be inflicted upon any person exceeding the prescribed by the law in force at the time such offense was committed. The prosecution operating in speech is fine with political rhetoric and general description lacking material evidence, real evidence, and the legal element of alleged crime. In conclusion, because to conclude I must, we will respectfully invite your Honorable Special Court to render the 8 accused person not guilty of any crime. Thank you.
Okay. It's good to when a written
defender lawyer defender talk right la defend lawyer gwaza mani tin kona shaling dio janta dong ba adjon ja kap chong dia ba kap kurun ke gwaza kana je kone bika right time so te ngwan long ti cherian lat jere ngai kona no che kon dial ten content chala de ken chana kaling ko chicken de dial chicken ke laran go chirek machar chirek chagalat okay
لقد تقدم الأستاذ مولانا بين تشكيل ممثل الاتهام لتأجيل جلسة يوم غد الثلاثاء. إننا في الدفاع نعترض على الطلب الذي تقدم به ممثل الاتهام للآتي من أسباب. 1 لقد ظل سيف الاتهام سلط على رقاب المتهمين منذ نهاية مارس 2025 إلى يومنا هذا.
Latin chalana win mako kona larger and million kona guasame Shidaman Shaling dear Jasha, defense lawyer, Shaman Lada Shah Jelling, defense lawyer, Ramdan Chiro Nimandan, Leggy, take a tongue one to Jalat. Kenyam, a persecutor, Chikarajan own and Tech Alat, Kadnasser, Kenny, Daking Machar, and the Alkanet Kona Yan Kale taken Katetin, Chiganala. Connecticut cave the Nakitan you the no she riek machar she can do you can lot can riek machar can podkan ke Gabriel Doblam ke Gadwich can ideal cocaine can tea taken katet kamedan asia or a lot so kuja money can taken kadur but gwaza me kaman chalat Ramadan la different lawyer riek machar shela de wona kuna kukan le GND ka juba Shukan wona kad Nasser ngai kona no okay chanamuling.
It has taken long, and in the interest of justice, it should move very fast. However, there are procedural requirements that we cannot jump, and that is providing this court our evidence. So we're requesting this adjournment not because we don't want to proceed. We want to proceed, but the requirement is that we must submit this evidence to court, so that it will be in the custody of court as we proceed with the court proceeding. It is our right as well to request for the same. So we insist on our prayer for adjournment, so we proceed tomorrow in the morning after submitting and verifying with the court police all the evidence that should be submitted to the court. It is not our own making, but it's because of the speciality of this court, the nature of this court, the uniqueness of this court. If this court was existing on its own before, we would have done this long before today. Thank you.
You see, it is for these reasons we allow even the defense to respond, while we are aware that Section 124 doesn't give the defense the right to respond. This is number one. Number two, we agree with the request because each and every party is supposed to give evidence in a thorough manner. Therefore, the session is going to be adjourned up to Wednesday after tomorrow. Thank you.
My Lord.
Go!
Joe Shaling Guasame, Shatogano Chad, Chaja Kapka after tomorrow, Shirun, Chakapka, Shanka, Dioja Shanka, Dishang, especially Wednesday, Chananka Wednesday. Shikamishaling Guasame, first by President Chala Intelligence Immunity, Kariptala Peace Agreement, Edan Shatan, wa kuumɛ take a long code, can watch. Menadian Bagwasame, Chikaladone. La Nasser incident edana chitok a Kennedy special court take a long thing she can menchala she can reject and telemanang hybrid court in ke international standard dobadan de kalugaja kenny no more telemenang katin nyok gwade me chikan laden wone ne dangro la two advocate tilla different lawyer ka dakrang machar chikan ka kapchong ko she can be continue unless she can appeal Chief of Justice dia she can content tengarte te pindian netin content lakwar justice net content to look te pindian shirmanen yan magwaza mo ka jawadana shaling can be court case ba work molka shimarun cha duer wan go me cha kala ramadan chirwach janan alaman cha kula respond in a different lawyer chikala de wona ne ramadan chi duer ko ne go cha na cha kana kre we can answer wona ka general majuk ki general majur ken man chalet ka je kanete ko kien mi je kan karai ko chanet in kontila civilian cha kan tel mi kan attach tin mo tel mi kan laten chikala ne jen go cha di ni cha kan ka ken coordinated mi chalat netin kontila ne dakre machar chikan pot kan lat ken dial ko kien ko kan dial kan dang badak no ken ne tin kan kon cha do lat kan aser chika shu ne ngani kan galat bo tla ngenen wari ka tan dien ke ken kon la general ka kuumɛ SPLIO lat kenen wo kanediti tikan ka tet ka dobe dana ci korja to ga ka nasar kan sha coordinated attack cha jalat gwade dan e ci korja to ga cha jo mo cha ja kweneken gwasa meni ka dobe dan shi different lawyer shi kan lo ka je te ka duere ya lat gwasa me ti shala da kan Ramadan and ku Dr. Machar ku je defend jikala no ne Ramadan rajma latin wanten kokien la all these crime tin cha committed kanasir chaga jogo no evidence kun kane tinyu do shine ka shikan duar shikan lat ko mi cha da ku cha da ku logo no jen ceasefire violation kam ka revitalize peace agreement da na isha tan chikan ga nyago jogo no evidence kun kane ko be ku nyodo no pot kan cha ka nasir cha kur cha jaw tok ke da kama cha cha ka nasir ke ne dia kon the accused person chi go ka nasir lo chikan duar kan to go ni mi ke kan tok so kan na mo ikene ti no ban man chala de netin content kwa kir kwa defend chikan la wone ne Can take an evident, of course, evident ticket in Medan Chana Janen Mexico can answer Kachikon and Agano she can Tunigan go can re which in Vinami and I know she can tidial can call that Chermangai corner, she can Turikan can Lakan take a tidial. But Banangajano quickle and mandan and latka gwada me shi kujandan and tenatin contin lan wer ticketin ka target ke li ngai kono no baring machar and abaje dil yena kan kata dan gwi kono je but something is very clear here kamana na shala da wa gor ga jen wode mal dertin but mu kuma we ngot kam dong leda na mo shit ko ne ko ne chirwaj watar ku ka target ni ne contin kel ke reng machar shi ma o kan yekaneti the dongoran jeno de can justice they can provide rewika South Sudan ke luki de kon mal de kan no alo cha ne de kon tilla ne tilla prosecutory ke prosecution team ka do dan right kan ka cha gu no kan tikan ke interest metika ga ka tok de kon ngaje no ramimo minyiri dire lugudi la ja wida wubutin dia la kontin dong de lat kaje cha te dia le konte kon ka linka constitution cha ka lokan dia but take a kill me be a link which right in Ramadan pay right ke jok ala different law ya dung da machar chela do ne a janan take a would kill me take Sudan ka gwase dan jen a lawyer ke prosecutor a me cha jogo no jin bi would kill me chet ke da machar bi represent ke bi defend cha we cha na bi defend cha jogo mu cha we tele kuumɛ min yin karam mo ano e ka dire wutin ka jen kuma dana yena ka dire defend bi lar no to dire chwanga mo dire je kede matuok ala interest dien man te ke kuumɛ ken interest dana te ne o ken chi jen dan ko ken yena mo ka ken lep ko da bo wa ken because of the rule chi men cha lengwa men wo cha defend lo yo cha ko overrule ke cha ka jot ka te kan kala do revitalize peace agreement ken constitution dana cha la den tieng ma cha te community ko cha de joj ke cha de kapin ka kwar ke cha de trial ka jen ko la special code me chi kala do ne kene na meni chi tok so chi anen wo cha ka dak kan different lawyer dak ma char ka kuiko ken lat ken la toka cha la toka jen mandana chikana lat so jen kwala gujeno jin me jira mi mo mi la prosecutor no ka birada dien no be interested bi jella la ci guru me la tokten ko na men joje gwano do be dane ci ko to gaje la gaje no sis violation no but chikala no tiken ka witness niken of course tiken ka witness ko ne te konte chanang te cha kut kana ser te cha kut ko lang te cha kut boka dore te ka ko baga kujimi kana diala ti ken la witness ne wona ka ne ken ton konte la noren konen guje no ken e chun kan kel ka ke so mi na me shi kon tok ko na bejekten unless achi konwe ka molka kamana banu ko evident ngai kon gan wobken gan no la to ko shi ko shi kara jino cha na cha kan cha yag yer cha cho cha ka lel cho na ti cha te ka gwa dan ti ko je tok ten ko yara diu of course gwa ko ri shang la ko la te ten ala do badan en gwe ken wer wai ami ka ja gwa me cha gu je lo ka civilian gwe ka lo ke de ne che de man cha ling no ken wa e pot kan kan ko kiene ken ten kontin te kan tin te ke link ken wer wai ami ke kan jog na den wo now ya nakana ki ya nyenya kana banne me kur men me chana ene no chirenyal che bok ji Uganda bara ina ngude kan ngwane kan kenenung ngai kono no te ke bren ngwan ko kuumɛ ti chigan ke realeka of course ngai kono mani an go baje win ngode beje but chana ngaje no rek woken ka wonyam na mani a beginning ko telle justice me ba provide rewika so Sudan chire man linya na gwas mani so na me der gwan wodi yenaling bana chuan gwas mani chirman chialing janda na chitwok our court case ba wewe ka shatin kon shalat la cha kuumɛ spla yo cha ko der ka tin kon ikan kalat gwas mani buna na ke vidani no mi ka twok wala shika twok ko jikara no kan shikan chicken record ne ka WhatsApp chicken ga jek chicken video ne chicken ka jek bane ka chicken document one te chicken lado chicken ka collect chicken ga jek to bikan ka provide ka shanga dan and wo eye witness ne wo ka ben ko eye witness ne ke de ne tin content ben gwa da tikitin ke de ne shiga civilian so kan kuumɛ SPLA yo kan narwach no matikan ke evidence te nyu dan wo chi de ne shiga na chicken ka nak ngod telma chala tan cherma ngai kono chicken na ga mena ga de ne no but to still telma chana latin dio je ko gwasen be bantu wantu ko kien bana kaling especially next tomorrow ko run cha ko cha ja jon ke je lo chi cha ko run cha je be chebele run belen ni molka so jen gwa dana gore de kon chongtin chirmana na shaling gwase me en go code bo we mola tel tok me shaling na wale shi wona kuumɛ mala kuumɛ kirm yadi de kaniten kontin shilat ki cha no kono shi cha law kam shene mene so na me gor jeno de yene lingan ban nyawje gum rodien gor jeno biati ti biya ko gor kendial chireten kon lat ko rodien ani biate kamal bana jek ka lerten ko kenen kontin bawden lat